time, I'd like to call to order the October 12th, 2011 Planning Commission meeting. The records show Commissioner Bob Nance is absent. All other commissioners are present. At this time, we'll approve or deny the October 12th, 2011 proposed agenda.
Mr. Chair.
Okay.
Mr. Chair.
Mr. Dumas?
I'd like to get some clarity on how to go about doing this, and I'm not sure how to do it, but I don't know if I'm supposed to make a motion to amend the agenda or what, but item number 9, based on legal advice, I believe that item should be deleted from the agenda. It lacks the legal requirements of proper advertisement. There is no clear action. The matter appears to be outside the powers and duties of the Commission. We don't have the legal authority to do this, and potentially could be in violation of state law. So with that, I would move to amend the agenda or approve the agenda minus item number 9, however you think it's appropriate to voice that.
I'll second that motion.
As I understand it, if the agenda as presented is proposed, any changes to it would be an amendment to it. So it would take it used to take a 2/3 vote. It would take a unanimous vote.
That would be if you add something to be considered that is not on the agenda. That requires unanimous vote of the.
My understanding was any amending of the agenda took a unanimous vote. You couldn't just do that. Then it still takes a 2/3 vote, correct?
Well, this
Or is it
is
just a majority vote?
I think it's just a simple majority to amend the proposed agenda.
To amend the proposed agenda just takes a simple majority.
Well, in this instance, you're deleting an item. You're not adding a new item that the public was not noticed on. If you were to add a new item, it would require unanimous vote.
All right.
Delete an item, it's simply a simple majority.
But this has been in the newspaper. It has been noticed. So you're
But when you all move items off the time, it's not.
well,
It's not
okay. I have so.
Mr. Chairman, in that this item number 9 deals with the homeless house project, I believe it would be appropriate if Commissioners Satterley and Kluwat recluse themselves from this vote, and that they've been involved in that in a controversial manner earlier.
This does not pertain to the homeless house approval. As the approval itself,
Am I misreading the words here, homeless house project?
the emails pertain to the homeless house project. The homeless house project has been approved. Kevin Kelly is moving forward. He's gotten his approval. This
Well,
pertains
I'm
to
just
the
interested
emails.
in everything being
That's
done
what-
in an ethical manner.
Mr. Chair, I think we have a motion and a
I'm
second.
trying to get to that.
Okay.
If I
Move on.
would be allowed to
Move on.
continue,
Thank you.
please.
Move on.
I have a motion and a second to, and correct me if I'm stating this incorrectly, to remove item 9 from the agenda, or to approve the agenda with item 9 removed.
Correct, sir.
By Julio Dumas, seconded by Howard Dalton. Is there any opposition or discussion?
Opposition, object.
All right, we'll go ahead and we'll
Mr.
do a
Chair.
roll call. Go ahead, Mr.
I mean, I was
Darrell.
just interested in how this item got on the agenda and what the intent as far as discussion and commission action would entail.
Very well. I placed the item on the agenda. The past 2 months, we've gotten a set of emails entered into the public record. And as I started reading those emails, I have some very serious concerns in regards to those emails. I indicated that information to legal counsel when I was asked. And as far as a commission action, I'm not going to dictate to this commission what it's going to do. We don't have the authority to investigate this stuff, but I believe we do have the authority to vote whether or not to send it to an investigatory agency.
Chairman.
That is all, and as far as the legality of it, quite frankly, I don't think it's legal that the commission is supposed to be hearing the historical site overlay when it has nothing to do with the subdivision of property. Yet that is what this group is the historical site overlay was approved by the planning commission. Therefore, the emails should appropriately be placed in front of the planning commission for review and decision.
Mr. Chairman, I feel strongly that if any member of this commission, or anyone else for that matter, feels that there's an ethics violation and they have any kind of evidence, they should immediately proceed directly to the Ethics Commission and let us dispense with this political grandstanding.
How is this political grandstanding, Mr. Dalton? I'm just curious.
Well, we know for a
No,
fact that, I'm going to tell you if you'll let me answer your question. Would you like me to answer the question?
Answer the question, please.
One of the commissioners here co-authored a PowerPoint presentation and worked with them in collusion. He's running for office, and the person presenting the thing run for office. Now, if that's not political grandstanding, I don't know what is.
Mr. Chairman, could I respond to the comment about me authoring?
Can I respond to the comments first,
Yes, sir.
please, Mr. Sally? Mr. Dalton, I don't give a rat's who's running for political office right now. I see some wrongdoing, or what I consider to be potential wrongdoing. Let me say it that way, since that's how I gave it, Ms. Manning, the information. In regards to how an applicant received an approval, okay? Has nothing to do with anybody running for political office, nothing. Now, yes, I could have taken this straight away to the ethics board. I have the right.
I think you should.
Excuse me, Mr. Dumas. I don't
I
need
apologize.
The problem is, it doesn't just involve me. It involves 9 commissioners, not one. Therefore, I think it only appropriate that any other commissioners that have concerns should be given the opportunity to voice those concerns. That's
To what
it.
end?
And
To what? No, Mr. Dalton.
This accomplishes
no-
nothing that this commission is empowered to do.
Mr. Chair,
This commission
if
is
I
not
may,
empowered to go ahead and take care of its own house.
Mr. Chair,
Come on, Mr.
Miss-
Dalton, Mr. Dumas.
I just want to point out something. I think state law is very clear about what you can and can't discuss in a public forum. Okay, and I think that for you to open this door, for some of the commissioners to make some of the statements that they may or may not make, and I emphasize the word may, I think you run the potential of slandering people and exposing members of the commission to litigation. Litigation that people will seek, what have you. Now, if I'm not mistaken, the parish has made it very clear that it is inappropriate for us to do this. And for us to proceed with this, if I'm not mistaken, we're not going to have the benefit of protection from the DA's office or the parish's, lawyers. We're going to have to go out and defend ourselves individually. And there's no way around it, because, some of the comments that you may make, and frankly, you know what, I'm personally not concerned. I'm going to tell you that right now, because I know I didn't do anything wrong. But you might find out that some of it may turn around and be very embarrassing for some folks here on this commission. And I would suggest to you that it is all inappropriate. If you want to have a public lynching of staff or any one of us in the commission, you need to understand that there are consequences for that. And the state specifically says that there is limits to what you can do in a public forum. And I think that this, and where this is headed, and where some of the PowerPoints, because some of these emails were doctored up in that PowerPoint that were not the complete email, are very slanderous in nature. And for that, I can't begin to tell you how strongly I feel it is inappropriate. If you want to do this, then let's do it in executive session and then report back to the public. But if any one of you feel like one of us did anything wrong, then I encourage you, please, don't wait another day. Write a letter to the Ethics Commission, write a letter to the Attorney General's office, write a letter to the district attorney, call the sheriff, do whatever you got to do, but do it. Do it individually, do it collectively, it doesn't matter. You have an obligation to do that. And for you to come here and do this in a public forum, you're going to subject all of us to potential litigation.
Mr. Chairman, I believe I asked for the floor earlier.
Mr. Sadler.
I have last meeting, and again, I see now in this meeting, been accused twice of being an author of a PowerPoint presentation. And then I just heard the term that another commissioner used, that I doctored something up. I wish to state the following for the record. I think it's important that everyone understand, so that we have a level playing field, what exactly is an author. I have been an author hundreds of times in my university career, and I've had my original scholarly work published hundreds of times, published, keyword, in refereed journals. An author, by definition, is broadly defined, and this is right out of the dictionary, any of us can read it, as, quote, the person who originates or gives existence to anything, unquote. Quote, authorship determines responsibility for what is created. Narrowly defined, an author is the originator, and I place emphasis on the word originator, of any written work. I authored last time nothing, and I plan to author nothing again tonight. Please allow me, Mr. Chairman, to contrast that with what a publisher is, or the act of publishing. Publishing is defined in the dictionary as the process of the production and dissemination of literature or information. It is the quote-unquote activity of making information available to the general public. The PowerPoint presentation being referred to by my fellow commissioners last time and again this time is nothing more than publishing published records. And I'm guilty only of assisting the public in doing so, and I would do so again. After all, what do we have to hide in this parish if we can't publish material gained by public record request from ap.gov.us email addresses? I want to repeat, I am not an author. I am and have been and am willing to be again a publisher. As Thomas Jefferson said, and I ask everyone to consider this quote, every government, that includes parish, not just state and federal, degenerates when trusted to the rulers of the people alone. That's our governmental officials Mr. Jefferson was referring to. The people themselves, everyone in this courtroom, are its only safe depositories. He's also been known to say, and others, that when the people fear the government, there is tyranny. When the government fears the people, there's liberty. I ask tonight that no one be afraid about who authored what, but that we put the actual words of the people who authored those emails forward so that this body can decide if there was any potential wrongdoing, and if so, what should we do about it? Thank you.
All right. We had a vote taking place this time. I'm going to go ahead and do a roll call vote on the motion to adopt the proposed agenda without item 9.
I'm for
Mr.
that.
Dalton, you're for.
For.
Mr. Barrett, for. Mr. Dumas.
4.
Mr. Kluwat.
Against.
Mr. Sadler.
Against?
Mr. Escobar.
Against.
Ms. Zarazua Gradine.
Against.
Motion fails. Still need a motion to
Motion. Second.
have a motion to adopt the proposed agenda by Milton Kluwat, seconded by Dan Sadley.
That's not correct.
Oh, I'm sorry, by J.B. Esnard. Opposition or discussion? Motion passes. The agenda is adopted. Or the proposed agenda is adopted. Item 4.
I'm sorry. I raised my hand. I thought you were going to go around the room.
Yeah.
I object to that. I apologize.
I would like the record to show that I object as well. I didn't realize what you were doing. You've always gone around with a roll call before, and this time you didn't.
Because for the agendas and the minutes, we said we just do
I
opposed.
apologize.
Did
I
a
did-
roll call for the amended motion, for the first motion, so I assumed that you were going to do that. So I
All right,
just
then
for
let the
record,
let the record show that we have 2 objections Commissioners Dalton and Dumas. Motion still passes. Item 4, approval or denial of the minutes of the September 14, 2011 Planning Commission meeting.
Motion.
I have a motion by Daniel Sadley, seconded by Milton Cluott. Any objection or discussion?
I'm going to abstain because I wasn't here.
Okay, I have one abstention. Commissioner Dalton. Motion passes. Item 5, public comment period. This time, anybody wishing to come up and address the commission on any item that is not up for public hearing or is pertains to the commission, planning commission, please come up and sign in, and you'll get your 3 minutes to speak. For anyone that hasn't picked up an agenda, that does include item 9. Okay. No one wishing to speak during the public comment period. Item 6, public hearing to approve or deny the following family partitions. 6A, Lance A. That Gajan property, lots 2-B-1 and 2-B-2.
Good evening, Clint Quetmal representing W.J. Quetmal Surveyors. Asking for the following family partition to be approved. Make sure. Okay, all comments have been addressed except for my client Lance. Moved the shed behind the existing mobile home until a new mobile home was put on his son's lot. I'm going to have him remove it. It's within the 20-foot rear setback. It used to be in the existing 15-foot servitude along the eastern line, right there on the northeast, about northeast from 40 foot from the mobile home on lot 2B2. That mobile home on 2B2 has now been removed. At the time, the date September 27, 2011. It was not removed at that time, but it is now removed. There is no structures on lot 2B2. Thank you.
Any comments or questions from commissioners? There are no comments or questions from commissioners. We'll open up the public hearing on this item. Anyone wishing to come up and address the commission, please sign in with the list there where Mr. Compton is.
Yes,
Please state your name for the record, sir.
Joseph Buckley. I own lot 2C. It's right next door to his lot. And a couple of questions that I have on the splitting the two lots is moving another mobile home in. What's it going to do to the value of my property that's right next door? Because if you look at the lots, they're not real square. And not to mention is, like I said, the other question I had is like I moved from Mississippi over here, and I know back in Mississippi is when you have a well water, you can only have a septic system. You have to have so much room, and that's the only concern I would have is because this trailer, the other mobile home he's got rented out, and there's a lot of people, there, so you're going to be a lot of wastewater going somewhere. That's the only concerns that I have on that is because, what we're going to do with it. If there's a different system over here that does away with it. That's the two concerns that's the biggest one is what's it going to do to the value of my property by doing us another, is it going to increase it or decrease with it being that close to me?
Okay. Thank you, sir.
Yeah.
Mr. Quetwell?
Yeah. As far as the value, that would be hard to determine, I guess, due to the current economic situation. The value of property goes up and down. I don't see that moving an adequate mobile home or a nice mobile home onto the property would do anything to his particular property value. But I'm not an appraiser, nor have I ever been. So with that, that's just an opinion. and it is what it is. As far as the sewage, I think the health department would require the proper situation for another mobile home, like in any other subdivision in the parish. I would assume, and the health department is going to direct Mr. Gajon in doing the correct thing for the sewage, since that is their area of expertise.
Mr. Chairman.
Mr. Kluwat?
Clint, he's doing a family petition, right?
He is, yes.
Okay. The house, the property that has the mobile home on it right now, is that where the applicant gonna live?
That is his property. He is giving the back lot to his son.
Okay. Does he live
Ashton.
on the front lot? Does he live on that one?
From what I understand, it's used for rental income at this time.
So that front
there's
lot,
no-
where that trailer is a rental trailer, he's renting it out?
I believe so, yes.
Okay. And he's gonna give the back one to his son,
Correct.
and his son's gonna move
At
the
some
mobile
point in
home
time.
on?
Well, at some point in time, there's no, I don't know.
That's what I'm talking about.
Yeah, I don't know the agenda of the applicant as far as a requirement to build or move a structure on a lot. I don't know. It's never quite been an issue or a regulation or a requirement in previous subdivision applications.
Is that all your comments, or
Yeah.
you have anything else? That's already existing. It's already existing.
Yeah, okay.
All right. Any other comments or questions from commissioners?
I have a question of staff.
This is not executive.
Pardon, Mr. Dumas?
I have a question of staff.
What's your question to staff?
I need the clarification on their interpretation on the code on the use of the front property as rental property and justification to generate a family partition like this.
Is that really staff more so, or legal?
I'd like their interpretation of code before we ask legal, see what they have to say.
Fair enough. Mr. Lewinberger?
I mean, my understanding of the intent of the family petition is to allow a parent to dedicate their land for their children to build on in a hardship situation. So, I mean, I can't really comment on using it for a rental, but I mean, that seems to be what the intent of the code is.
But if it- I'm sorry,
if I may
Mr.
ju- When you received this application, were you aware that this was being utilized as a rental property?
No.
Okay.
I guess that's where I'm going through. Theoretically, this is supposed to be a hardship situation. And if I'm a parent and I have a hardship, I would presume that is to have my offspring close by to assist me. That's generally been the practice of the hardship. It's not to manage rental property. So I'm wondering if this meets the requirements of provisions of family partition.
Chairman,
Mr. Dalton?
I've looked through this packet several times, and there's supposed to be a hardship here, and I see nothing that really shows me, unless I didn't get the hardship letter. Well,
I mean, the hardships,
the hardship, if this is what that was, the unique shape of the property. To my interpretation, the hardship would be that a family member wants another family close or something of that nature. He can do a simple partition with some other changes, but I mean, I don't believe this would qualify as a family partition, certainly not for a commercial property to be put on it. I mean, for commercial use, i.e. a rental property.
Okay, I'm ready to comment whenever y'all are done.
Mr. Kluwat, you had a...
Yes, I agree with Commissioner Dumas and Commissioner Dalton. I want a clarification that if he does do a family petition and he does have rental property on one of the lots, does that meet the code? Is that okay? Can he do that? In other words, if he's gonna give it to his son, the back lot to his son, and he's got the front part as rental, and he's not living on it, then how does that face becomes a hardship to where he's living by his parents or his father or whatever? Is my question, is my concern.
Mr. Lewinberg, you have anything to add to your previous comments?
Oh, no, I didn't know if that was a question directed at staff or if that was just a question to the commission.
Mr. Chairman, any information you can give me would help me, please.
I mean, and again, like, the intent of the family petition is for a parent to dedicate their children or grandchildren or parent or grandparent a lot in a hardship situation, and I think it's up to the code doesn't really clarify what the hardship situation is other than what is regularly defined as the hardship, and so at the end of the day, it's kind of up to the commission to determine if they're in a hardship situation.
Thank you.
Any other comments or questions from commissioners? Mr. Quintmall, you had some comments you wanted to
Yes.
address.
I think we need to be very careful in what we are attempting to interpret a code to saying that a person with whatever acreage, whether it be 10 acres, 5 acres, 100 acres, that they are not allowed to subdivide and give a child a lot because there is a rental on the property. Now, in this particular case, of course, this is not a 10-acre tract. I don't think there's a delineation between the two, personally, but that's just my opinion. But to say that someone cannot have a piece of property and use it as a rental and have the right to do that and then give their child a piece of property as the family partition allows, then that giving the child the piece is the actual hardship, not that there's a rental on the piece that the owner is retaining. The intent is to give his son a piece of property in the rear. And the client's willing to get up and explain his hardship if necessary. If you deem he needs to get any more personal or into his personal business that y'all would like to have put aired on public television, he will do so. That is up to y'all.
Mr. Chairman, I have a
Mr.
question for staff. In the quote-unquote hardship letter, and I quote, it says, "The unique shape of the property and lack of public road frontage prevents a simple partition." The question I have for you, is there any way, other than through the family partition with quote-unquote hardship, that this landowner can partition this land?
I mean, there is.
And that would be?
I mean, they'd have to go through the actual subdivision process of having to do what the subdivision code allows, because the family partition gives them the exemption of having to build a road and having to go through the different drainage and traffic studies and like a normal subdivision would do. And so if it couldn't go through a family partition, it would have to go through
The normal
the
subdivision
regular
process?
subdivision process.
Okay, thank you.
At one point in time, we used to do a simple division of property with a variance. And I'm still curious. I've never gotten an answer to the question of why is that illegal? If the commission can grant variances to any part of the subdivision regulations, simple division of property is just that. It's a simple division of property. And the variance typically was creating a private road to get to access a part of the property. Anybody care to answer that?
By definition, a simple division of property is a division of a piece of property where you do not have to build a road. And to simply say that we're going to apply a variance that then says you have to build a road doesn't make sense. If you want to be able to allow a property owner to subdivide a piece of property on a private road, you need to add that to your code and not simply apply a blanket variance to a person to not just make up the code. The code was never written to allow a property owner to subdivide on a private road, because every time they did it, they were looking at the family partition standards to determine what the width of the servitude was. If you want to do a simple division with a variance, write the code to create a minor subdivision where you can build it on a private servitude of access, because right now the code does not allow that. The application of the variance on a simple division doesn't make sense. A simple division means you have road frontage.
Thank you. Comments or questions from commissioners? Not, what's the wish of the commission?
I'm going to make a motion to deny this family partition on the basis that it does not meet Section 174026 of the code.
Have a motion to deny this family partition by Julio Dumas. Is there a second? If there's no second, then the motion fails due to lack of a second. What's the wish of the commission?
Mr. Chairman, I'll
Blue
second Mr. Dumas's motion.
Mr. Dumas, would you mind restating your motion, please,
Yes, sir. I make a motion to deny the family partition on the basis that it does not meet the criteria of Section 174026 family partitions.
I have a motion to deny this family partition by Julio Dumas, seconded by Milton Kluwat. Discussion.
And I
Dalton.
don't have my book with me. Could I get that read into the thing or I could just hear it, the actual reference? I don't have my book with me.
174026 is family partition. It talks about the hardship and
Could you read that?
dedication to
Because I
children.
don't have it. I don't have my book with me, and I apologize.
Are you asking him to read the entire ordinance or just the section?
Part that's applicable here.
It just says, whoop. Let me get back to it. It just simply says that the following procedures shall be followed for the hardship subdivision of family property, each containing at least 1/2 acre, and then it continues on several pages, all of the various criteria. But this is a hardship, that's always been based on a
I
family
was
base.
just wondering if it gave any more detail on the term hardship.
It talks about, on several paragraphs, but it doesn't define it. No, sir.
Any further discussion? At this time, we'll go ahead and vote. Mr. Dalton?
I'm going to have to vote against this.
For the approval or for the denial?
Well, the motion is to deny. So are you voting against?
And I have to disagree with the motion because
Okay.
there's no other way they can
Voting no.
subdivide.
Okay. Mr. Barrow?
I agree with the motion.
Mr. Dumas?
Yes.
Mr. Kluwat?
I vote for the motion.
Mr. Sadler?
If I understand the question, if you vote yes, you're voting for Mr. Julio Dumas's motion and not for what Mr. Dalton said?
Mr. Dumas has made a motion to deny the request. So if you vote yes, you're voting
Favor of
to
his
deny
Right.
the request.
Yes.
Mr. Esnard?
Yes.
Ms. Zarazua Gradine?
No.
I have 2 nays. Motion passes. Item 6B, Sloan Young property, lots 6-B-2-A and 6-B-2-B. Mr. Quintmo, go ahead, please.
Asking for planning commission approval on the following Sloan Young family partition. We have 6B2 and a 6B2A, 6B2B.
Okay. Comments or questions from commissioners?
Mr. Chairman?
Mr. Barrow.
Oh, I was trying to find out here from the staff recommendations, is the applicant willing to reduce the private servitude of passage.
Mr. Quintmore?
From what I'm reading, the staff recommends that lot 6B, 2B, not front along Louisiana Highway 44 unless the proper frontage is given to the lot. This particular design was done back when reference map number 6 was done, and we created 6B1. Design and intention to have the property put into the back lot, and for each of the side lots to have their own frontage, although the plan of the client is to have all lots exit out on to the 40-foot servitude of passage to eliminate multiple driveways. I see no problem with the design.
Okay, I guess I was talking about number 3, which says recommends the private servitude of passage be reduced to 20. And they're saying if you would do that, that they would recommend waiving the T-turnaround requirement. Is that correct, staff?
Yes, that's correct.
Yeah, not reducing.
You don't think they'd have a problem with that?
Yes. Reducing is fine.
Okay.
Mr. Chairman,
Thank you.
Mr. Dalton?
if I heard Mr. Whitmont correctly, you said that all 3 lots are going to access that private servitude of passage to reduce the driveway connections. Did I hear you correct?
That is the plan, yes.
And the staff recommendation says, staff recommends the private servitude of passage be reduced to 20 feet, as this servitude will be providing access to just one lot.
Correct.
So my question to staff is, and that we now know that all 3 lots are going to use this servitude of passage, are they still making the same recommendation, and that servitude of passage will now service 3 lots?
I guess once again, I'd have to ask the question, was staff, when this application was submitted, was staff aware that the intent was for all 3 of these lots to, Sloan Young Lane to be the access for all 3 of these lots?
Well, I mean, typically, when those 2 lots will still have road frontage along Highway 44, so the private servitude of passage will still be just a dedication for the lot to the rear there, because the other 2 lots will still have legal frontage along a public road. So
Yeah, let me go ahead and restate my question. Was staff aware that the intent was for all 3 of these lots to be accessed by Sloan Young Lane? Yes or no? Did y'all know that their intent was for create a private servitude of passage, but they wanted to access all 3 lots off of that? That's all I asked.
no.
Okay. Any other comments or questions from commissioners? Not, then we'll open.
Mr. Chairman, I have one, excuse me.
Sure.
On that staff. So in other words, you're basing your decision for a 20-foot based on the fact that the 2 front lots do have access to Highway 44.
Correct.
So even if they would want to use the private servitude of access, you still would be allowed to drop it to 20 foot, just because they frontage on Highway 44.
I guess I'm confused.
Sir?
Because right now, lots 6B2A and 6B1, they front along Highway 44, and so they have legal frontage along a public highway.
Okay.
Now, I mean, there's nobody going to be out there policing and making sure they're not using that private servitude
Right.
of passage or whatnot. But I mean, when it comes to lot 6B2B, theoretically, if the commission goes with our recommendation, will not be fronting along Highway 44, and thus it will need that private servitude of passage, which will be 20 feet accessing the rear of the lot.
Mr. Quintmore, is your clients aware of that, of all the scenarios?
My clients will, I'm assuming, will change their intentions for granting approval of this thing. If you wanted to pull out 3 different driveways, they'll probably do that for you if you would like. So if you want their intentions changed, just
Thank
throw
you.
it out there. Okay.
Any other comments or questions from commissioners? Not, then we'll open up the public hearing. Anyone wishing to come up and address the commission at this time, please come up and sign in, and you'll get your 3 minutes to speak. No one wishing to speak on this item? Very well. Public comment period's closed. Comments or questions from commissioners?
I'll make a motion to approve, subject to the following
Mr.
corrections.
Dumas, just, wait, I'm not ready to entertain a motion just yet. I just wanted to make sure that everybody had their questions answered yet.
Okay.
All right, what's the wish of the commission? Mr. Dumas?
I'd like to make a motion to approve, subject to the following corrections on the plat. On the dedications, on the third dedication down, Clint, where you reference the servitude hereby is dedicated for means of access to, it needs to reference all 3 lots. Then an additional comment be made that lots 6B1 and 6B2A shall have access only from Sloan Young Lane. And grant the variance. Oh, and reduce the width of the private servitude from 40 feet to 20 feet, and grant the variance.
I second that motion.
I have a motion to approve with condition by Julio Dumas, seconded by Milton Cluott. Discussion. No discussion. If there's no discussion, we'll go ahead and vote. Mr. Dalton?
Yes.
Mr. Barrow?
Yes.
Mr. Dumas?
Yes.
Mr. Cluott?
Yes.
Mr. Sadley?
Yes.
Mr. Esnard?
Yes.
Ms. Zarazua Gradine?
Yes.
Motion passes.
Thank you.
Item 7, public hearing to approve or deny the following minor final subdivision plat. 7A, the Burns property, MD LLC, lots 2-A-1 and 2-A-2.
Thank you. My name is Brian Aguilar. I represent John Dunlap Surveying. And we are asking for final plat approval on the minor subdivision that you have in front of you.
Comments or questions from commissioners? Mr. Esnard?
From what I understand from Mr. Ward's letter, he is still requesting the cores be taken?
Mr. Chairman, I could perhaps answer that. I
Mr. Sadler?
reviewed the property this morning, and I saw 2 distinct drill core holes in Lot 3A. Is that the cores that are in question?
Yes, sir. From what I understand, they did take the cores, and
I don't know the results, but I can see the holes.
I can't tell you the results either, but originally they did physically bring the cores to Mr. Ward, and he stated that he wanted a report form, and I think they were in the process of that. I do not believe they did bring that report. Is that true?
Yes, they need 1 additional core.
They took 2 core samples, and they need 1 additional core sample?
Yeah.
Okay. Mr. Esnard, is that,
Well, the other thing too is that makes the comment, Mr. Aguilar makes the comment in his letter about adding the curb would block access to the truck loading docks. So in other words, this road would never be accepted into the system without that curb.
Correct. They have no intention to ask that the parish take over this road.
That was it.
that's all? Okay. Any other comments or questions from commissioners? Not, then we'll open up the public hearing. Anyone wishing to come up and address the commission on this item, please sign in, and you'll get your 3 minutes to speak. No one wishing to speak. Public comment period on this item is closed. Comments or questions from commissioners? Commissioner Sadley, do you want to make a comment, or?
Well, with Before we entertain a motion, Mr. Chairman, can we proceed without the third core sample, or is it necessary with the two and with, I guess I don't know how the motion can be phrased, but if someone could make a motion that the third one will be, looks like Mr. Dumas might have this handled.
Well, typically, I was going to ask staff, usually to go out there and core sample and do a report, doesn't take that long, does it?
Not usually, no.
No, so I guess the
They just,
motion I would make.
they got 2 cores, we got the plan, wasn't quite in the right place that we want them, so we asked for an
A
additional
third,
core.
okay. I would make a motion to approve the final plat, subject to, with the variance requested, subject to the parish receiving the third core and reports reflecting that all cores meet parish standards prior to the chairman signing the plat.
Second.
Have a motion. First, any other comments or questions from commissioners?
I apologize, Mr. Chairman.
Well, I have a motion to approve with condition by Julio Dumas, seconded by Dan Sadley. Discussion. No discussion, then we'll go ahead and vote. Mr. Dalton.
I'm for it.
Mr. Barrow.
Yes.
Mr. Dumas.
Yes.
Mr. Kluwak.
Yes.
Mr. Sadler.
Yes.
Mr. Esnard.
Yes.
Ms. Zarazua Gradine.
Yes.
Motion passes.
Thank you.
Item 8, public hearing to recommend approval of or denial to the parish council the following servitude revocation. 8A, Seven Oaks subdivision at Oak Lane Farms, first filing, lot 41. Is there anyone here to represent this item? There's no one here to represent this item, then
Mr. Chairman? I
Mr.
would like
Dalton.
to request that we move this to the end of the agenda and off chance that they may show up before the end of the meeting.
have a motion to move this to the end of the agenda by Commissioner Dalton. Is there a second?
I'll second it.
Seconded by Commissioner Kluwak. Is there any opposition or discussion to this motion? Then item 8A will be moved to the end of the agenda. Right after new business. Item 8B, Plantation Creek, Lot 10. Please come up. No. You don't have to sign in. You're the applicant.
I'm Tony Wiles.
Chester Wiles.
We wrote a letter to the commission asking that part of the servitude be revoked. We, from the end of our patio to the back fence is 27 feet. And in the planning of building a pool, we investigated and found out that 15 feet of that 27 feet is a drainage servitude. In the worst of storms, we've been there for 5 years. And in the worst of storms, we've never seen the water back up from the back of the fence to 5 feet. And we're only requesting that a portion of that be waived.
Okay. Is there anything else you'd like to add? Is that
No, sir.
comments or questions from commissioners?
Mr. Chairman,
Mr. Barrow.
looking at a letter here from, looks like DPW, and it says here that they had made a visit, and it reveals that there appears to be enough room for a pool to the right of the rear patio where no encroachment will occur within the drainage servitude. Are y'all aware of that?
I know what you're referring to. However, there isn't enough length there. If you look at the diagram I submitted with our request,
Mr. Chairman, what size pool you plan on putting?
it is 32 by 13, 14.
Mr. Barrow, did you have anything else you wanted to ask? You were bringing up the letter from drainage, I believe.
Well, I guess just to follow up, you said to look at the drawing where they're saying to put it on the right of the patio. That would be away from the drainage servitude. Is that not possible, or what's with the size pool that you're looking to have?
We have a cover that goes over the patio. I've got to get beyond that. And with the fence on that other side, it just wouldn't work there.
Okay.
Mr. Chairman?
Mr. Sadler.
Ma'am, what would be the distance from your drawing where it says patio and you have the 9-foot mark, the little 4.5-foot sidewalk next to that? It goes 19 feet and it looks like to the end of your home, but then the distance between there and the fence of your adjacent, of your neighbor is not clear. So what's the distance from that 9-foot dimension all the way to the fence?
But they've never stated how
Um,
much.
I don't have my drawing with me. Actually, on the drawing, I only outlined to show you where the house was, and I only addressed what came off of the patio. I didn't even address the right side, because I knew it wasn't going to work.
Could we put this on?
Mr. Chairman,
Mr. Esnard?
it looks like if he's saying that his scale for each block is 2 feet, that would roughly be 31 feet from the edge of the patio to the fence. Okay? And therefore, if you're building a 32-foot pool, that wouldn't work.
30 foot.
She said 32.
I'm not 30. Is it
May I
32?
speak? The
30 or
the
32?
cover, what you're
No,
seeing is...
The pool.
Right, but you referred to the right side of the patio?
Yeah, but what's the size of the pool again?
It's 32.
32.
So it wouldn't go.
However, what you're seeing is that right edge of the patio. There's a cover to the patio that extends past that. There's a swing there, and so we built the patio cover further out. It goes beyond the slab.
I understand.
Mr. Chairman,
Mr. Dalton?
unless I'm just missing it, and I may be, I keep seeing where it says that you want to revoke a portion. A portion could be anywhere from 1 inch to the whole thing. How much are we talking about? Are we talking about 1 foot, 5 foot, or 20 feet?
I would like to obtain half of it waived. I was advised not to put a specific portion in there.
Well, I think you're going to have to, because I'm certainly not going to vote for a blank check. How did this get by staff?
Have you considered, I'm sorry, Mr. Dalton.
I'm sorry, that was a question. How did this get by staff?
Well, let's ask them, staff, how'd this get over to us? If it sounds like we've got some. I mean, I don't know. First, let me ask, who told you not to write a specific amount as far as a portion? Who just told you to leave it open like that?
The pool company.
The pool company. Okay. Yeah. Well. Okay.
I did, however, in speaking to Jeffrey, I can't pronounce his last name. It starts with an L.
With the parish.
In the office.
Okay, Mr. Leuenberger over
yes.
here. Yeah.
He told me, I did discuss that with him.
Okay, so staff, you were aware that they were talking about reducing it not the full 15-foot servitude, but a portion of it,
I mean, the
part of it?
The request came as a portion, but the recommendation from the drainage department was that none of it gets reduced. So, from a staff standpoint, there was no reason to put a measurement on it because the drainage department is saying that they recommended none of it get revoked.
Okay. Well, Mr. Dumas,
I was just going to ask, have you discussed with the pool company the possibility of reconfiguring the pool or reducing the length of it?
No, I have not.
Because if Commissioner Escher is correct, from the edge of the patio on the let me orient myself here. No north arrow, great.
31 feet.
From the edge of the patio on the south side of the patio, you have 31 feet. So you could conceivably shrink the pool 3 or 4 feet and make it work on the side.
No, sir. That edge of the patio that you're looking at, the cover
There's a swing there.
of the patio that is into the roof of my house extends far beyond that. I didn't
towards
draw
the
that
rear?
in.
Far,
No, towards the fence where you're quoting that distance.
so what you're telling me is that 4.5-foot sidewalk is under roof, and beyond that is under roof.
Yes. May I say something?
yes, ma'am, please.
I have a letter from the engineering department that says that they recommended and approved. May I give it to you?
First off, what's the date of that letter?
September the 19th.
Okay, I don't know the date. The letter that I've got is dated September 22nd.
This is the only letter that I have received.
Yes, let's keep it for our records.
Why don't you put it on the screen?
Put it on the screen right there next to you.
Right, I don't know. You know, and there's an overhang here and over here.
Do a little bit harder so they can see it.
Post. Can't run the overhang, but the patio's on it, cover's got a post.
You know from here to here.
No, that's what I was saying, I don't know. It's probably around 6 to 8 feet.
Y'all seeing, gentlemen?
Yeah.
Y'all seeing? She's adding this portion.
It's this right here that's in question.
Mr. Chairman,
Mr. S. Norman.
the overhang, the cover over the patio is supported on the patio and not on that area outside of that 9-foot side of the patio. Is that correct?
I didn't understand.
Yes, it is,
It's supported on the concrete patio.
at the very edge of it.
And so your pool is 32 by 14, and from the 21-foot edge of your patio to the drainage servitude is 12 feet.
Yes.
But,
Yes,
can I
ma'am.
say something?
Please.
Something that I was told in planning out the size and the dimensions of the pool was you have to consider the slope. What I actually need is the deep water to be able to get in. And you have to look at the elevation of the bottom of the pool. And it wouldn't even be safe at a certain angle, you know, going from shallow to deep.
Okay.
So you need so much length to be able to obtain that.
Are you diving or are you swimming?
No, I'm exercising.
Swimming,
Exercising, yes.
swimming back and forth.
No.
Or water aerobics.
It's exercises that has been ordered by the doctor. I would not call them aerobic. I'm not capable of that.
Well, how deep is the pool company said they want to make this pool, that you've got such a tremendous slope?
It's gonna be 6 feet deep on the deepest end. So he's gotta go from 3.5 to 6 feet. That's a typical pool you get nowadays anyway, is 6 feet deep, 5.5, 6 feet.
Well, I'm pretty certain.
The issue, what I would look at when we're talking about going to the fence that separates us from the neighbors, you may be 31 feet, but you can't get 31 because you're right there on the fence and you're gonna cut into that and the wall has gotta be brought back. So in essence, we're cutting probably down to about 28 feet to go in there. And then the neighbors next door, I've got a pool right over where the kids can stand up and look over and fall right into it. We're trying to keep the pool away from those neighbors' fence, and the kids climb up on everything else on the fence anyway. And if I have a pool and they fall right over the top of my fence, then they're gonna say, my child drowned in your pool because it's built right up against that fence over there. That's another reason why I'm asking for the, little bit of the servitude to be revoked going down into that 15-foot.
Mr. Chairman,
Mr. Barrow.
I was interested in seeing that letter. Could you put the letter on the screen? Let's see. Is there a focus somehow?
Yeah, but she probably didn't know how to do it.
Staff, could you help her focus that?
So this was dated, looks like 3 days prior to the letter we got.
What's the date on that?
September the 19th. I received it September 23rd.
Well, the letter was written the 19th, the site visit was made on the 20th, and the letter that we have was written on the 22nd, so that explains that.
Well,
After the site visit, they changed their.
but the thing is, the very last sentence, this is not a guarantee that the servitude will be revoked, but merely the procedure that is in place for such revocations.
They're just simply advising
So-
you how to apply for it.
Yeah.
Right.
Okay, thank you.
Mr. Chairman,
Mr. Kluwan.
is there any way you can get with your pool company, knowing the area you have to work with, to reconfigure your pool to some other way that can achieve what you're trying to achieve and stay out of the servitude? In other words, can you take your plan and get with your pool company and tell them, look, I can't go into the servitude, and I need this? Can they maybe have to configure the pool instead of 30 by something? You might have to go with a little bit more different dimension.
Okay, if it's 30, y'all came out with 31 feet from the fence?
Yes, ma'am.
Okay, if you subtract 8 from that, we down to 23. And then I've got to have at least a walk around, plus the edge of the pool has a coping, and that's another foot minimum. You realize how short that is?
Yes, ma'am. But you got to understand one thing too, ma'am. If we allow this and then the water starts backing up 3 or 4 lots back, then what happens?
I disagree with that comment because I don't think it will, because even putting the width, and I'm planning to put it as close to my patio as possible, there's still going to be more than enough room for drainage. The worst drainage I've ever seen has never come anywhere near what the edge of that pool is going to be.
Did you sit down with staff and drainage and explain that to them? And because we got a letter here saying that they denying it, that it's not to do it.
I spoke to Jeffrey. He's the only person that talked to me about it. I made 3 trips over there.
Yes, ma'am.
We obtained the paperwork and filled it out long before this letter. I was kind of confused when I got the letter,
Yes,
why
ma'am.
it had the forms that I'd already filled out and submitted. That's how they knew to come to my house. When I got this letter, they'd already come to the house. I had already filled this out and paid my fee.
Any other comments or questions from commissioners?
I just want to confirm, you're in receipt of the engineering department's letter dated September 22nd.
No, sir, this is the only letter that I have ever gotten. However, this is also signed approved.
No.
What's the difference?
That's the director approving the letter. That's just the director, Bill Rue, approving the letter.
Does not. He's approving that Ascension Parish does not approve this request.
Correct.
So that's the part he's approving.
No, he's simply stating that the letter is correct, that
Oh,
the denial
okay.
is correct.
Okay.
If I may, Mr. Chair.
Sir.
We're an advisory, so we're not the final decision here. So this will go to the council for final action. But drainage is it's a major issue. It's in everybody's mind on every single development that we address. And I empathize with you in your desire to have a pool that's adequate for what you need. And Mr. Chair, if you're ready for a motion,
I have a comment if I may.
Yeah, okay. Mr. Dalton.
Because of the drainage issue here, and I'd like to be able to use their land as they want, but by the same token, we have an obligation to try to protect the other residents and not put the parish at potential in a liable situation should there be a drainage backup. No matter what you're saying, we have to consider that. And I have a real problem with the blank check type of thing. And what I would like to, and it's just a suggestion, but I would suggest that you go back to your pool, that you withdraw this application so you can come back in a month. Go to the pool company and say, look, I need a definitive amount of servitude. How much, you recommend 2, 3, 5 feet, and come to us with a definitive number. And because if this goes through and gets turned down, they have to wait how long before they can come back? 6 months, a year or something, if this gets turned down?
No, they can come back. There's no
No time limit.
no time limit. It's not like a zoning case.
Okay, I'm sorry, I'm confused. So, but anyway, I have a problem with it being a blank check.
Okay, when you commented earlier about a blank check, I told you that we needed 7.5 feet, if y'all could waive half of it. And I also stated that in the worst of weather, and we've lived there 5 years, we've never seen more than 5 feet.
That 7.5 feet is not gonna block that drainage. It's into it a little bit, but it's still gonna be able to flow. It's not like we're asking,
Well,
build a pool all the way to the back.
but your application stipulates the full 15 feet. That's
Can
what
we
we're-
change
that's what
that
we're
here
looking
now, or
at.
we have to resubmit?
Well, let me get back with you on that in just a minute. Commissioner
done.
Barrow, you had it, okay. Thank you,
Yes, Mr. Chair, I believe Jeff earlier had said that his understanding of the DPW letter is that they don't approve any amount. Is that correct, Jeff?
What's that?
Whether it's 1 inch or 15 feet, they don't approve any reduction. Is that your understanding?
That's the way I read the.
Okay,
the
so
letter.
then Mr. Dalton's idea of coming back and saying, oh, it's 5 feet or 10 feet would not really matter. We'd still have the same letter from DPW, correct?
Correct, yes.
Okay.
Okay. The thing is, though, Jeffrey, when this information was sent to the Drainage Department, if they're given, they say, well, the 15 feet or any part thereof, and they don't know what any part thereof means, is it safe to say that if they did go, we don't know if they would reduce it by 7.5 feet or not, do we? If that information wasn't clearly given to them, if it was just given as open end, oh, we want to reduce just a portion of it, what's the portion? We don't know. Is that safe to say that chances are they would not reduce it, not knowing a specific number?
I mean, I can't speak for drainage, but the recommendation from Drainage Department says this, Ascension Parish does not approve this request for the revocation of a portion of the existing 15-foot drainage servitude. And that's, planning staff doesn't give a recommendation, but, and I can't speak for drainage to say if they would change their recommendation, but that's what the letter states.
And I understand that as a portion, but I'm asking as far as a specific number.
Who knows?
Well, we
Mr. Chair.
don't know. And, well, if I'm, folks, if you want to revise your application, you have every right to go ahead and pull this application before the commission votes on it to bring it back as an amended application. That, you always have that right. I'm not saying that's what you want to do. I'm simply letting you know that that is an option if that's what you do want to do. I'm just saying that.
If I may, what I'm hearing though is it doesn't matter if it's 1 inch, we're not gonna approve it. That's what I'm hearing. So I don't wanna waste people's time or mine if that's gonna be the case.
I
Mr.
understand.
Chair,
Mr. Dumas.
I think what the chairman's trying to tell you is that, the application, one would presume, based on their response, that they're not going to approve anything. But it really is presumptuous on our part to say that, because you weren't clear in your application how much you wanted to remove. So what I would suggest to you is that maybe you, and I'm going to have guidance here from the chairman and legal and staff whether we can do this or not, but that you simply ask for a postponement for 30 days, come back in 30 days. In the meantime, meet with DPW, get your pool contractor to look at it in a creative way so that it's something other than a rectangle, and see what's the absolute bare bones minimum of this drainage that you need a waiver from, and see if you can convince the Department of Public Works to sign off on it. And
It's still going to be 7.5 feet. Also, the letter, it's signed by Darrell Primo. Him and Bill Rue are the people that came out to my house.
They looked at the situation and they're
If you can
recommending
call
approval
that
as
looking.
engineers and telling me that, yeah, we're evidently wasting our time.
Well, they're saying in the letter that they think there's ample room for you to build a pool. That's what they're saying in that letter, if you read it carefully.
Still, in any case, what we decide here tonight is just a recommendation. The parish council is going to have the final say on this, okay?
I understand
So there's
that.
still another step in the process.
I'm aware of that.
Any further comments or questions from commissioners? I'm trying to remember, did we open a public hearing on this or not? I don't think we did, so if anybody wants to come up, wish to come up and address the commission on this item, please come up, sign in with on the list right here where Mr. Compton's sitting, and you'll get your 3 minutes to speak. No one wishing to speak. Public comment period's closed. Comments or questions from commissioners?
I have.
Mr. Kluwat.
Did you, Mr. Applicant, would you come back? Did you understand what Commissioner Dumas was saying? You don't want to give it one more chance to go before all the like DPW and stuff like that? You don't want to try one more time?
Sir,
And say, look, we need this amount out?
We can, but I'm saying, I'm retired military, so I read regulations a lot. When I hear a gentleman tell me that's disapproved because they're not gonna prove anything at all, then I feel like I'm wasting my time at that point. That's all I'm saying to you.
Well, I think they're, and correct me if I'm wrong, fellow commissioners, I think they're saying no because you didn't identify how much you want to take out of it. And they wasn't gonna give you a blank check, so they just said no.
That's partially on me, but I'll tell you, if I was making those decisions and I saw an applicant that said portion thereof, I would at least send back something saying, let me know what your portion is. We could have resolved this before we ever got here at this point. I didn't read that letter correctly, and I thought it's been approved. So I would have came here differently. But if any request is made to me saying a portion of, if not all, and I didn't identify that, somebody at the parish level should have got back with me as a taxpayer saying, what are we talking proportion? I need a set amount of footage or whatever. That never happened. So that I'm a little disgruntled as a taxpayer in Ascension Parish. or disappointed the fact you have a letter, because I didn't read it completely, because I don't understand the workings of the politics anyway.
Well,
But
would
when
you
I
like,
hear someone tell me that it's disapproved, they did it, and that's the way it is, and we don't do any servitudes, that's the way it's set up, then to me, that says I'm wasting my time to put forth any more effort on it.
well, but would you want to, like,
I will try what you're saying.
then you would have to withdraw this and we don't
No.
act on it
No.
tonight.
I'm
No.
saying-
Actually, I think we can defer it for 30 days.
If they
That's
don't
what I'm
want
talking
to,
about.
They don't want to.
No,
I do not want to do that. I'm the
Okay.
one that made the request, and I do not want to do that.
That's,
Okay.
Then my option is we'll sell our house and I'll go find someplace.
That's
I can
right, out of
and just
Ascension
move it
Parish.
somewhere else.
Mr. Chairman?
Mr. Sadler.
We have, I believe the motion, although the word wasn't used by the commissioner who asked for it, tabled the Seven Oaks subdivision revocation of servitude. And I noticed Department of Public Works says no objection to the revocation of 6.5 feet of the existing drainage servitude, provided the remaining 7.5 feet remains intact. So these things do exist in terms of a recommendation, at least up to this body. So again, I find myself an ignorant beast awaiting my education.
Join the club.
In other words, we have another in front of us that DPW is okay in it, a 6-foot something
Boy, I understand.
revocation. So if you just don't want to do that, don't want to take one more chance and one more time to go back to the staff and everything, then I
I
understand.
spoke at great length with Jeffrey about this. He knew that my letter was open-ended, and I was going to leave it up to someone else to say, okay, you know, this is how much we can allow you. Because I don't know. I'm not an engineer. I'm a registered nurse. I don't do that for a living. I wanted somebody else to say, we have 15 feet servitude, and this is how much we can allow. Can I ask a stupid question?
Yes, ma'am.
I'm just dying to know this. We hardly have any backyard, and we've got 15 feet of drainage servitude. Who decides these things when the guy behind us has no drainage servitude at all? He drains totally on our drainage servitude. Who determines that?
that goes through our staff, it's reviewed, and I'd have to look and get all the dates as far as,
The property behind us is private property that they subdivided, and there was never any drainage servitude, but we've got 15 feet.
well, there again, no, it's private property, and how, you know, I don't know how it was subdivided, when it was subdivided. There's a difference. It all depends on when it was done, how the code was written at that time, and so forth. So I'm saying, I don't have any of the background information on Plantation Creek, so it's difficult to answer your question specifically. As I stated before, all we're doing is making a recommendation to the parish council. So there's still another step.
I
Now,
understand
it
that.
is possible, I believe it's possible, that you still could, that you stated that Bill Rue and Darrell Primo came to your home and looked at the area. I don't know what else to tell you. Right now, all we can do is make a recommendation,
Okay.
and then it's up to the council. Then
All
whether they
right.
choose to accept that recommendation or reject our recommendation.
I understand.
That's where we're at right now.
Yes.
Okay.
Thank you very much.
Any other comments or questions from commissioners? There are no other comments. What's the wish of the commission?
Mr. Chairman,
Mr. Dalton?
I'll move to deny based on the letter from the Drainage Board and the lack of any other real option. So I move we deny, or recommend denial.
I'll second that.
I have a motion to recommend denial to the parish council based on comments from the Drainage Board. You also said any other issues associated with it? Or any other items?
No.
Okay. Well, by Howard Dalton, seconded by Julio Dumas. Discussion. No discussion. At this time, we'll go ahead and vote. Mr. Dalton.
Yes.
Mr. Barrow.
Yes.
Mr. Dumas.
Yes.
Mr. Kluwat.
Yes.
Mr. Sadley.
Yes.
Mr. Esnard.
Yes.
Ms. Zarazua Gradine.
Yes.
Motion passes. As I said, this is only a recommendation, which the council could accept or they could reject. Item 9, emails entered to the public record plus others regarding the Homeless House project and related matters. This item is for discussion amongst commissioners and action. As I stated earlier, in the...
Mr. Chairman, excuse me.
Mr. Kluwat.
Before this gets started, I'd like to enter this into the public records. It's a
All right.
disc with information on it, and I'd like the disc and the information on the disc entered into the public records. And I have some data that I also would like entered into the public records in the minutes of this meeting.
Very well.
What's the content of that disc?
Thank you, Mr.
Mr.
Chairman.
Kluwat, could you give a general summary of the content of the documents on the disc, please, sir?
It is the emails and attachments that was received through a request for public records.
All right. I stated, past 2 months, there have been emails entered into the public record pertaining to events with Homeless House. And as I read and reviewed each of these emails, I became more and more concerned. And to start with, this is not a trial. Nobody's being placed on trial here. Nobody's being called out for anything. This isn't a witch hunt. We have issues here that I believe potentially to be violations of an ethical nature or criminal nature. No, we do not have the authority to investigate. I do believe, though, we have the authority to take some action as to whether or not we want to send these items to an investigatory agency. And there are a number out there, of them out there. The commission could decide it just wants to drop the issue altogether. Some comments were made about a PowerPoint presentation. Well, there's no PowerPoint presentation in this. This is strictly the emails. And
Well,
whoever authored these emails, well, you know, I can't help that. I'm aware, because I was there's emails in there that I authored. Oh well, shame on me for authoring an email or responding to an email. But there are emails in there that pertain to members of the staff, members of the administration, as far as receiving and sending out emails. We got a complaint letter from an applicant that it ends up, I see 3 different versions of this complaint letter roaming around, which the letter was sent to a member of the administration and says, make whatever changes you like. Now, yeah, I have to take exception to that. The applicant's complaint letter should have come straight to the commission. I'm not going to get into a big question session tonight. I don't think I need to hear much in the way of any explanation one way or another. At one point, I wanted to ask a bunch of questions. No, I don't. I'm not worried about answers tonight. I'm really not. We have a stack of information here that, based on its content, can be interpreted 100 different ways. Well, when you do that, you're bound not to find the truth. And one thing I have found here, especially here lately, with the internet and such, finding nobody likes their gossip ruined with the facts. So I don't want us to ask. Personally, I don't really want us to ask questions tonight or get into a big finger. It's not supposed to be a finger pointing session. Accusations don't need to be made. I think there have been more than enough accusations made. One of the emails that I saw, the same day that the commissioners got the complaint letter, commissioner sent an email to the sheriff's office making what I have to look at as some very serious accusations with really very little evidence. As I said before, there are agencies out there who will make the determination whether there is a violation, whether it is ethical, whether it is criminal. They'll make the determination, and if it is determined to be a violation, they'll make the determination whether it's human error or if it is malicious intent. That's their job. That's what that's part of their function. So, personally, let them take it. Let them have all this. Let them make the determination. However, as I said before also, it's not just me. There are 8 other commissioners involved in this. And I believe every commissioner has the right to go ahead and speak his or her piece, if they so choose, in regards to this. At this time, I'm going to shut up. I'm going to go ahead and let the other commissioners. You find something amusing, Mr. Dalton?
Yes, I do.
Would you care to share it with the rest of us?
Not particularly.
So if there are any comments or questions at this time from commissioners, this is the time to go ahead and speak.
Mr. Chairman.
Mr. Esnard.
You know, I have to agree with what you're saying, especially after reading through all these emails, that it just leaves me wondering what was actually going on before we ever got the application for Homer's House. You know? And there again, being you on the commission, when we looked at Bocage, I just kind of wonder about the advice that was given and the direction that was taken with Bocage. So, yeah, I think there's good reason that we all should be concerned.
Thank you. Any other comments or questions?
Mr. Chairman,
Mr. Kluwak.
I have serious concerns pertaining to the Homer House approval and events leading up to that approval based on emails and other documents submitted to the public record, submitted into the public records on August, September, and October 2011 Planning Commission meetings. This information needs to be submitted to an agencies with authority to perform a proper investigation into the matter, and I would support this investigation. This decision should be made by the commissioners and not just the chairman, to submit this information to the proper agencies. Thank you, Mr. Chairman.
Hey, Mr. Kluwak. Mr. Sally, you had something you want to comment on?
Just something that Mr. Esnard said struck me. I was also a new member, and I believe he was talking about the previous application, so specifically I'll put a label on it as Bocage. And I was concerned to learn, I wasn't in the room last time, as everyone knows. I was in the conference room on recusal on the Homeless House application, and I learned that another commissioner had full knowledge that the PUD overlay actually covered the former applicant's property, Bocage, and chose for the reasons he stated, not to bring that forward to any of us. I too would have certainly appreciated knowing about that, and I would also go on the record in saying that had I known about it, my vote more than likely would have been different at that time.
So let me ask you a question, if I may.
You're recognized.
So your objection is that I did not point out to you or to any other member of commission information that's in the code that you were handed, that's been available in the public, and that has been a rather hotly contested, hotly debated, and unpopular overlay. You know, I think staff is charged, and we are charged individually, not in collusion with each other, to interpret the code and come here with an independent, idea. Yes, I knew that that overlay was there, and I still to this day feel that it's not applicable. The code has specific provisions that requires us to interpret the code in a particular way, and I believe, I did not discuss it with staff, but I believe that they made a similar discovery and similar analysis, which is why they made the recommendation that they made. So that's fine. I mean, God bless you. I don't think the commission has the power, the authority to take action and mandate and send something to an investigative party. I encourage you, every single one of you, to do so. And let me say something, because at the very beginning, and this has to the homeless house as part of these emails, you can call it publishing, you can call it authorship, you can do whatever you want to when it comes to that PowerPoint presentation. I think the properties of the file clearly labeled it, clearly identified it. It is what it is. It was a collaborative effort, to afford a group of individuals from the public to make a presentation and slander individuals. And it focused primarily on an allegation that staff went there at 3 o'clock in the morning. And I have a question for all of you who worked on that PowerPoint presentation. Did anybody bother to check that Xerox machine or any other Xerox machine or a scanner in the parish to see if by any chance their clocks is set properly? Because I did. I went after the meeting and I asked somebody at DPW to scan something for me. In order to scan it, it has to be scanned into one of their accounts. So I had Angie, who's got nothing to do with Ricky's group, to scan it at 9 o'clock in the morning, 9:10 to be specific. You know what time that scanner had? It had 4:15 a.m. So I went to inquire as to why. Every week, the generator on that building recycles in the middle of the morning. And when it recycles, it power cycles all of that equipment twice. When it kicks on and takes a load of the building, and when it shuts down and reverts it back to commercial power. It recycles the time twice. And it sets the clock back to 12:01 a.m. And nobody bothers to reset the time because it's not important. Here it is. You guys want to go on a witch hunt, you want to slander people, you want to do things that are outside the power and the authority that we have in the commission. If you have an issue, you all sign your letter and send it to whomever. God bless you. That's your obligation. To have this public meeting and try to character assassinate people is totally malicious on your part, and you should be ashamed of it.
Mr. Chairman.
At least humor me that the recusal and participating on the PowerPoint presentation, if it wasn't unethical, since I'm not a lawyer and I do not know the ethics law, and if it wasn't, at least it was somewhat deceptive, and at least humor me and call it hypocritical.
Mr. Kluwak?
Mr. Chairman, I hear what Commissioner Dumas is saying, but I was very offended if he's saying about come see first and come see second and all this stuff, when I read in those emails that he wrote a letter to the sheriff accusing me of something that I was cleared of. In other words, he was not man enough to come before me and ask me if I did or did not do what he accused me of doing. So I would think that all of what's going on right now needs to be stopped. Let's turn this information over, and let's see if anything was done wrong. If nothing was done wrong, then let's everybody move
Mr.
on.
Chairman?
Let's go on with life. It's no witch hunt or anything of that nature on my part. I just want to see, after reading those emails, I have concerns. I'm not accusing anybody of anything or doing anything wrong. But I just would love an independent agency to look at all of this, and if they come back and say nothing was done wrong, then great. I really hope it would be. But to just sit here and say that nothing was done wrong after reading those emails, I think it's wrong on my part by not wanting an investigation done by an outside firm.
Mr. Dumas?
Mr. Chairman?
I'm merely saying that you do what I did. You have a concern, raise it to the appropriate authority. If they find that you're wrong, you're wrong. What I'm saying is that this commission it's not empowered to do what we're doing. You have an issue, package it up, pay the postage, ship it to the right person. If you want to email it, email it. If you want to hand deliver it, hand deliver it. You need to do it on your own. You have an obligation to do it. You should do it. But make sure that you stand behind what you said, and make sure you accept the answer.
Mr. Chairman, the commissioner just spoke. Mr. Cluott referenced a letter written against him. The same letter was written against myself. I believe I have a right to speak on that, retained by a public record request. This is on July 13th, and I hope the clock was correct. I don't know, 10:53 in the morning, a couple hours after the Homeless House complaint letter went forward complaining of blackmail against Mr. Cluott and myself. And I'm not going to read the whole thing, but I'm going to read a sentence. It's not my words. I'm, again, not the author, but I am publishing. The attached correspondence, meaning the Homeless House letter, is clear evidence of the extent of collusion and extortion of these individuals. Written to Sheriff Wiley. I would like to know, in any kind of investigation, and whatever happens, why a fellow commissioner wouldn't have contacted me and asked for my side of what happened out there, instead of just going directly to the sheriff and asking, in another sentence later on, that you undertake a thorough investigation of this matter. There's always, Mr. Chairman, two sides to a story, and I would prefer that have been done in this case, but it apparently was not. If that letter is clear evidence, I also wonder why the APSO and the district attorney in separate and in collaborative investigations cleared the good name of myself and Mr. Cluott when the evidence, according to this commissioner, was clear that we were collusionary and extorters.
Any other comments or questions from commissioners? Not. What's the wish of the commission?
Mr. Chairman,
Ms. Zarazua-Gradine?
I would like to make a motion to authorize the chairman to organize and submit all material to any appropriate agency for further investigation, and to appoint someone to assist you if you find it necessary.
I second that.
Have a motion to move forward with getting this information organized and taking it to appropriate agencies for further investigation. Discussion. Made by Commissioner Zarazua-Gradine, seconded by Commissioner Esnor. Discussion. Discussion, and we'll go ahead and vote. Mr. Dalton.
Well, I'm all for a thorough investigation, so send it on.
Mr. Barrow.
Yes.
Mr. Dumas.
I'm all for a thorough investigation, but I'm going to vote no because I don't believe we have the authority to do this.
Okay.
I think you should individually do it.
Mr. Cluott.
Yes.
Mr. Sadler.
Yes.
Mr. Esnor.
Yes.
Ms. Zarazua-Gradine.
Yes.
Motion passes. Item 10, committee reports, our subdivision ordinance committee. Mr. Cluott.
Thank you, Mr. Chairman. We did not have a meeting last month. It was called to my attention by a fellow commissioner, Mr. Dumas, Commissioner Dumas, in relation to the number of people, or should I say, number of commissioners attending the meeting. And he expressed his concerns that another commissioner there participating in the meeting would come under the belief that it may be the full commission meeting. So I advised Mr. Dumas that I would contact legal and get an opinion. Well, I did, and Ms. Manda gave me a opinion, and I'm gonna read this letter that I prepared, sent to all commissioners, and I will, as chairman, will enforce this. At the December 21st, 2011 meeting of the subdivision subcommittee meeting, Commissioner Dumas questioned regarding the legality of other commissioners attending and participating in the meeting. I informed Commissioner Dumas that I would get an opinion from Ms. Manda. And then I have see below the following email from Ms. Manda about the subcommittee meetings. And I'll say further on about other commissioners attending the meeting. I requested that everyone help the subcommittee in this matter. As chairman of the subcommittee, I would only allow the full members appointed to the subcommittee to participate in discussions, make and vote on a motion. All other visiting commissioners in attendance will not be allowed to participate in a meeting or speak in the public comment period, as it may appear to engage in the debate of the subcommittee and may violate the open meeting law. If a commissioner not on the subcommittee has a question or questions, please call the chairman of the Planning Commission and see if he will place it on the Planning Commission monthly meeting agenda under subdivision committee reports, or call myself and I will place it on the subcommittee agenda. If the subcommittee does not have a quorum, which we're having a trouble with that, and we have full members appointed on it, there will be no more meetings. There will be no meetings. If you have any questions in this matter, please call me. So I'm asking the commissioners on this commission that we follow these rules and that we don't get in trouble with the open meeting law. So from now on, any commissioner that's not a member of the committee will not be able to participate in that meeting. Mr. Chairman, I also want to cancel next week's meeting. We have a lot of information that we're trying to put together. There's a lot of questions that have come up. There's a lot of people have called me and asking me about a lot of things, and we're just not prepared to do it right now. We're gathering information, and I would like to cancel this month's meeting, and we'll pick it back up in November. Thank you.
Thank you. Okay, item 11, any items of new business to be brought up before the commission? They're not to be acted upon, just for discussion. No items of new business, okay. Yes, this becomes, we got item 12, let's see, item 13 to adjourn. Seven Oaks subdivision. This is a public hearing to recommend approval or denial to the Parish Council of a servitude revocation, Seven Oaks subdivision at Oak Lawn Farm, first filing, lot 41. Is there anyone here to represent this property? If not, I'll just go ahead and ask, what's the wish of the commission? Do we want to go ahead and act on it, or do we want to go ahead and defer it?
Make a motion to defer as the applicant's not here, and staff to please notify him that he has to be here.
I have a motion to defer till our next regularly scheduled meeting by Commissioner Julio Dumas to recommend to ask staff to contact the applicant. I have a second.
Yes, second.
Second by Commissioner Milton Cluott. Discussion. No discussion. We'll go ahead and vote. Mr. Dalton?
Yes.
Mr. Barrow?
Yes.
Mr. Dumas?
Yes.
Mr. Cluott?
Yes.
Mr. Sadley?
Yes.
Mr. Esnard?
Yes.
Ms. Zarazua Gradine?
Yes.
Motion passes. Item 13, I'll entertain a motion to adjourn.
Motion.
Motion by Commissioner Cluott. Is there a second? Second by Commissioner Esnard. Is there any opposition or discussion? Motion passes and we are adjourned.